Yes,
Please, Your Lordship. I beg to mention item number 13, Your Lordship. Taking consent from the petitioners.
yes.
2019 matter, Your Lordship.
Well, here I am appearing for the petitioner, my lord. It was actually listed as fixed matter. But what their inconvenience, my lord, if your lordship will fix it on first of. No, that we cannot say. Because my lord adjourned. Otherwise, do it today. It is on their prayer, their signature. Or then, no, prayer for fixing on a particular date is rejected. You talk it out amongst yourselves. Well,
This thing could be raised here. I saw no
it will be adjourned for 2 weeks. Otherwise, do it today. I am ready that we are inconvenienced. We'll call up the matter and see what happens.
I know.
Yes. No, all right, my lord. On their prayer, my lord, we'll look it there. Item 11. Nothing, sorry. On the prayer of Mr. M. Sharma, learned counsel appearing for the respondent.
All the respondents are
Appearing for the respondents made with the consent of the petitioner's counsel. Hearing of this matter stands adjourned for 2 weeks.
I'm grateful.
My lord, this matter for listing, my lord. It was last listed on 25/11/2022.
18 July. Yes.
May I please, Your Lordship?
Yes.
So without concern of others, I beg to mention item number 8. This matter may be taken after 2 weeks, Lordship.
You are for whom?
I am for the respondent TC requirement.
I appear on behalf of the petitioner, my lord. The matter relates to seeking compensation, my lord, by the 9-year-old boy who have lost both his limbs, my lord. Your lordship had had in land, my lord. In fact, who had lies for the your lordship had directed the Guwahati Medical College.
No, why you want adjournment? Let us see. Let the matter be called up.
Yes,
And we'll see. Let it be called up.
May I please, Your Lordship? Lordship, I beg to mention for listing of a rate petition for admission column, Lordship.
What is the matter about?
Matter is regarding some pensionary benefit, Lordship.
3rd week of June.
Lordship.
3rd week of June.
Oh,
Yes,
yes,
Lordship. Also, with the concern of the petitioner, Your Lordship, I beg to mention item number 6, Your Lordship. Okay, pass up for 2 weeks, Your Lordship.
Item 6, you are
Yes.
for?
Respondent number 1, Your Lordship.
On the prayer of learned counsel for the respondent number 1, made with the consent of the other side, hearing of this matter stands adjourned for 4 weeks. List accordingly. Yes.
On the
Your Lordship, I beg to mention for listing of the matter on the next Monday, Your Lordship. I highly, Your Lordship, for correction of order of Your Lordship.
May it please your lordship. I beg
Yes.
to mention hearing item 9. As my senior is out of station, matter may be come up in 2nd week of June, my lord.
That we can't say. It will be adjourned for 2 weeks. You are for whom?
Respondent bank, my lord, 1 to 4.
On the prayer of learned counsel for the respondent numbers 1 to 4, made with the consent of the petitioner's counsel. Hearing of this matter stands adjourned for 2 weeks.
Must authorize.
My lord, I could not find, my lord. Actually, there was settled position, my lord. Lordship is right that he has missed the bus. Good case otherwise.
Good case, good case.
Yeah.
All right, heard Mr. A. Hussain, learned counsel appearing for A. Ahmed, learned counsel for the writ petitioner. Also heard Miss
Mr. D. Nath is appearing.
Mr. D. Nath, learned senior government advocate Assam, appearing for the official respondents. None is appeared for the respondent number 5. Full stop. The writ petitioner hearing was initially appointed as an investigator on 03/03/1986 in the Fisheries Department. He has retired from service on attaining the age of superannuation with effect from
13/6/19. Yes. 19, my lord.
what is the date, please? With effect from so and so on attaining the age of superannuation. Full stop. The grievance of the petitioner is that during his entire service period, not a single promotion was given to the petitioner. Full stop. The same was because the post of investigator was not included in the cadre post under the Assam Fishery Service bracket recruitment and promotion bracket close order 1989. Nor was it, and therefore it was not the feeder cadre for the next promotional post of, what is the next promotional post?
Assistant Research Officer.
Assistant Research Officer post of.
28th February 2019 here retired.
The 28th February
2019.
28 to 2019. Post of. The petitioner seeks a writ of mandamus directing the respondents to amend the order of 1989, include the post of investigator into the feeder cadre for promotional post of assistant research officer, and thereafter consider his case for promotion. Full stop. On such basis, case for promotion. Thereafter, consider his case for promotion, and thereafter give him financial benefits by treating him in the cadre of assistant research assistant. Full stop. But the fact remains that the petitioner as noted above, the petitioner has retired from service during the pendency of the writ petition. Moreover, the writ court would not issue a writ of mandamus directing the respondents to amend the order only to incorporate the post of investigator in the schedule of posts which form the feeder cadre for the next promotional post. It is no doubt correct that the petitioner appears to have been wronged by denying him the avenue of even a single promotion during his entire service career. However, it is also correct that the petitioner has slept over his rights for nearly 3 decades, and just a few months before his retirement, the petitioner has approached this court filing this writ petition with the above prayers. First of, having regard to the facts and circumstances of the case, the prayer made by the petitioner cannot be considered at this point of time. As such, this writ petition is held to be not maintainable in law as well as in facts and circumstances of the case, and the same is accordingly closed. As such, about you right, it can be safely said that due to delay in approaching the court, the petitioner has missed the bus. Missed the bus in as much as entertaining the prayer of the petitioner at this belated stage would have severe upsetting effect. Missed the bus.
He retired already in 19.
Huh?
In 2019, he retired.
2028 to 2019. Yes. So if it was a simple case of consideration, then also we would have understood. But the rules do not permit. So first the rules will have to be amended.
Correct.
Yes.
May I please?
Yes, please.
My lord, I have prepared a short list of dates for your lordship's convenience. May I hand over.
Yes.
My lord, the essence of the whole matter, my lord, is certain improvement works that were done by PWD in Nagaon, my lord. 18th August 22, my lord, pursuant to recommendations by the MLA Nagaon Sadar for additional works relating to improvement of Nehru Pali ground, including so and so. the petitioner informed the city level CIDF implementation and monitoring
Who is
committee.
the petitioner? First of all, who is the petitioner?
My lord, I am an executive engineer, my lord,
Hmm.
and I am aggrieved by invocation of sealed cover procedure against me.
Hmm.
My lord, in one of the writ petitions, the other writ petition, my lord, I am aggrieved by imposition of a minor penalty of censure,
Hmm.
not in compliance with the rules, my lord.
What is the non-compliance of rules in
My
that?
lord, this honorable court, my lord, has interpreted Rule 9, Sub Rule 12B, that if a show cause notice is issued, my lord, giving an indication that a major penalty will be imposed, then midway, they cannot change course and impose a minor penalty, my lord. In my respectful submission, my lord, I am squarely covered on that point by
But
your lordship.
censure, there is no need to even hold an inquiry.
My lord,
Censure can be,
yes, provided, my lord, the notice indicates that at the very outset, at the initial stage.
hmm.
That's the way, my lord, your lordships have interpreted Sub Rule 12B of Rule 9, my lord. But if they have issued a notice, my lord, giving an intention to impose major penalty, midway, they cannot change
They
course.
will only have to impose a major penalty.
No. My lord, then they are bound to hold an inquiry. My lord, I am relying upon a judgment. I'll try to persuade your lordship on that, my lord.
So which writ petition pertains to what?
My lord, 448
Hmm.
pertains to the disciplinary proceedings, imposition of penalty, censure. And 356, my lord, pertains to the seal cover procedure and the denial of promotion.
So 356 obviously is prior.
Is
That-
prior.
That
is
was
prior.
filed.
It was
So
filed prior.
that you have come to the court at a stage when the departmental proceeding was going on or it was concluded?
No, it was concluded.
Hmm.
I had filed an appeal.
Hmm.
It was rejected in December.
Hmm.
After that, I moved 356
You had
first.
filed an appeal against the censure.
My lord, I made a representation, my lord, against the denial of promotion as well as imposition of the penalty, my lord.
Hmm.
That was considered and
Censure
rejected.
is considered as a penalty.
Minor penalty, my lord.
Hmm.
But that penalty also was imposed much later.
Hmm.
Invocation of the seal cover procedure, my lord, happened
Yes.
in September 21, when disciplinary proceedings were not even initiated.
Hmm.
All that had happened was, my
Okay,
lord,
all right, let us now go through your list of dates.
Yes, my lord. My lord, 18th August 2020, my lord, there were some additional requirements communicated to us by the Honorable MLA. And pursuant to that, my lord, we informed that there will be some additional fund requirements. My lord, this may not be a key fact, my lord. Then your lordship may come to the next date, 19th November 2020. Petitioner submitted before the additional chief engineer, who's my senior, my lord, Tejpur, a detailed working estimate for rupees 1 crore 99 lakhs odd amount, duly countersigned by the superintending engineer, who's also my senior, my lord. Your lordship may kindly have this page 36, my lord.
Just a minute. Let's
My
finish
lord.
the,
Right. Well, then 25th November 2020, the additional chief engineer approved the revised working estimate. Then on 31st December 2020, my lord, CCIMC approved the additional proposal for 1.50 crores for additional works and forwarded the same for administrative approval of the government. Minutes of the meeting were sent to the Director, Town and Country Planning. Deputy Commissioner Nagaon forwarded a bill for an amount of rupees 1 crore 25 lakhs 33,779 to the Director, Town and Country Planning. He acknowledged that the original administrative approval was for an amount of rupees 2 crores. The Honorable High Court was pleased to issue notice in writ appeal so-and-so filed by Assam PWD Engineers Association through the petitioner against Sri Devajit Das. Without issuing any notice to the petitioner, Department of Housing and Urban Affairs constituted an inquiry committee to look into purported anomalies in implementation of the project. The committee, comprising of Director, Town and Country Planning, Sri Devajit Das, and Joint Secretary, Department of Housing and Urban Affairs, prepared an undated report holding the petitioner and an assistant executive engineer responsible for procedural lapses in implementation of the scheme. According to the committee, the petitioner executed major part of the scheme on the basis of working estimate without prior approval of administrative department. This was the only lapse found on my part, my lord. 22nd September 21, without issuing any notice to the petitioner, Department of Housing and Urban Affairs wrote to PWRD recommending disciplinary action against the petitioner. 27 September 21, Department of Housing and Urban Affairs advised PWRD not to promote the petitioner. 28th September 21. Now, this is very crucial. 28th September 21, Milan. Selection board meeting for promotion of executive engineers to superintending engineers was held. Petitioner's name was recommended, but a decision was taken to keep his name in sealed cover till resolving the adverse report received from Department of Housing and Urban Affairs, while letter dated 22nd September 21. Thereafter, Milord, 16th December 21. That two inquiries were conducted by PWD itself, Milord. First exoneration was given on 16th December 2021. And they found, Milord, that the Director Town and Country Planning did not raise any issues to maintain procedure despite having knowledge of the ongoing works. Then, Milord, 9th March 22, Milord, the whole controversy arose because of absence of administrative approval. But on 9th March 22, Milord, Department of Housing and Urban Affairs gave ex post facto approval to the revised scope of work as well, Milord. 6th April 22, show cause notice after the approval had come, Milord. 6th April 22, show cause notice issued by PWRD to the petitioner under Rule 9 of the Assam Civil Services Rules, read with 311 of the Constitution of India. 29th April 22, second exoneration was given by a committee of PWRD inter alia on the basis of approval dated 9th March 22. 1st July 22, penalty of censure was imposed by PWRD on petitioner without considering exoneration given by two committees constituted by PWRD, without conducting an inquiry pursuant to the show cause notice in accordance with the rules, and without granting
This
any
show cause notice is page 91 of which read petition?
Milord, I have given the references to the second, this is 448, Milord.
All right, let us see the.
May I read, Milord?
Yes.
You are hereby required to show cause under Rule 9 of Assam Services Rules 1964, read with Article 311 of the Constitution of India, why any of the penalties prescribed in Rule 7 of the aforesaid rule should not be inflicted on you, and the following charges based on the statement of allegations attached herewith. While executing CIDF project in Nagaon town, namely so-and-so, an inquiry was initiated in the Department of Housing and Urban Affairs with respect to anomalies in implementation of the said scheme. You have executed the scheme based on working estimate deviating from the actual tendered items and submitted a running bill amounting to so-and-so without obtaining administrative approval of the concerned administrative department on the working estimate based on which work has been implemented. In the inquiry conducted by the Department of Housing and Urban Affairs, cum administrative department of a aforesaid scheme, it appears that both material change and variation in items have been incorporated in the working estimate as supplementary items, wherein an amount of rupees so-and-so has been considered as non-BOQ. It appears that you have prepared the working estimate amounting to so-and-so against administrative approval of 2 crores, restricting in the tender to rupees so-and-so without the knowledge of the administrative department. The said working estimate found to be approved by the additional chief engineer, Tezpur zone, based on which the execution of the work has been carried out. You have also failed to highlight the procedural requirements for execution of works as per revised working estimate in the CCIMC meeting held in connection with the aforesaid scheme, and submitted a running bill without obtaining requisite administrative approval and thereby violated existing norms and procedures of the government. You are therefore charged with gross negligence and dereliction of duty, deliberate inaction and non-compliance of the government instructions, and also violation of Rule 3 of Assam Civil Service Conduct Rules 1965. At page 92, Milord, are the statement of allegations. They have more or less repeated.
Yes, then what happened? After 92, what has happened?
Milord,
You submitted your reply.
I submitted my reply.
Where is it?
Lord, my reply, your lordship will find. Lord, I have filed an affidavit in reply in WPC 356, my lord. I have enclosed it with that affidavit in reply.
We'll not go into it. We can't go. Then what happened?
Well, Lord, then another inquiry. I said, my lord, there were two inquiries which were conducted by them, but they were not disciplinary inquiries, my lord. But they were,
what happened in this show cause notice?
my lord, a second inquiry was conducted by PWD's own committee, and they, my lord, found no lapses on my part.
What happened to this?
Ultimately, a penalty was imposed, my lord.
This one?
Yes. The minor penalty of censure was imposed.
No inquiry.
No inquiry.
So
No,
straight
no.
away censure.
Yes,
Where is the order?
Yes, my lord. My lord, may have page 97 of the same paper book, my lord, WPC 448. It's dated 1st of July 22, my lord. Whereas the additional chief secretary, may I read, my lord?
Yes.
Whereas the additional chief secretary to the government of Assam Department of so-and-so Urban Affairs submitted an inquiry report by letter dated so-and-so and recommended necessary disciplinary action against officers responsible for anomalies in implementation of the work so-and-so. Whereas Sri Biraj Talukdar, the then chief engineer, Border Roads, Assam, was requested to submit an inquiry report on the anomalies as raised in the report submitted by the Department of Housing and Urban Affairs, and Sri Biraj Talukdar submitted his report by his letter dated so-and-so. Whereas departmental proceedings has been initiated against Hiten Kolita by issuance of show cause notice by dated 6th April 22, leveling the charges of gross negligence, dereliction of duty, etc. Whereas a committee was also constituted to examine the feasibility of regularization of the work carried out, and the committee has submitted its report wherein it has been concluded that the
So you are
administrative
agreed by this order?
by this order.
We'll set it aside and ask them to go ahead with the full-fledged departmental proceeding. What is the case?
Well,
Censure is not a penalty.
Well, censure,
It cannot, you want to be promoted.
I want to be
They'll
promoted.
promote you. What is the problem? You promote him now. You can't withhold promotion by on censure.
As per government policy, lordship,
Ah.
once the censure has been imposed, lordship, now he will be considered in the next DPC, lordship. He will be definitely considered in the next DPC, lordship. One office memorandum I have placed, lordship.
The very invocation of the sealed cover procedure, Millard, which goes to the root of the matter.
No, it is
Millard,
not correct. My
that is
friend is saying
wholly
that no
incorrect.
inquiry report is there. After DP lordship, one proper inquiry report is there. Page 94 is there. I don't know why he is in his own writ petition.
Millard, inquiries conducted by the Department of Housing and Urban Affairs cannot be considered as a departmental inquiry, Millard. And in fact, their own inquiry, their officer, Mr. Biraj Talukdar, who conducted it.
Let us see.
Mail this.
So, Mr. Pukan, is it? Let us leave aside everything. There was a departmental proceeding initiated against your client, but the authorities ultimately decided not to go ahead with it and close the matter by imposing a penalty of censure. What do you have to say on this? What is wrong with this?
Millard, in very similar facts, Millard, your lordships have held
Where is
that
it?
such a penalty.
So your juniors have already been promoted.
Yes, they were promoted in November 21. Seal cover procedure was invoked against me in September 21, Millard. In fact, in this matter also, Millard, there were reports prior to issuance of show cause notice and earlier subsequent reports, my lord, which were completely ignored by this honorable court. My lord may have. Just to give my lord some facts, kindly have my lord paragraph 4, my lord. While the petitioner was serving as executive engineer in the Rongia NH division, a show cause
Let's
notice.
see the, Mr. Fukan, this judgment is not applicable in your case. The reason I'll tell you just now.
Fine.
Here, there was a penalty of withholding of one increment
Yes, and
and
censure.
then, and censure,
Well, the
not
obs-
only censure.
Well, but the observations on censure, my lord, are very relevant in my respectful submission
And
because
then the charges were held to have been substantiated. There is no such finding in your case.
no, my lord, in this case also,
Hmm.
findings were, the charges were substantiated, my lord, but the imposition of minor penalty of censure was found to have been bad because it was in complete non-compliance with the rules, my lord. If your lordship may have para 18 for a moment.
Yes. Give me the Assam Service Discipline. Paragraph 18.
Paragraph 18, my lord. A perusal of the show cause notice dated 14 June 2010 would show that petitioner was asked to show cause under Rule 9 of 1964 rules, read with Article 311 of the Constitution as to why any of the penalties prescribed under Rule 7 of 1964 rules should not be imposed on the petitioner. Rule 9 lays down the procedure for imposing penalties prescribed in Rule 7. As per Sub-Rule 1, no order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except after an inquiry held as far as may be in the manner provided in Rule 9. Thus, no penalty can be imposed without holding inquiry. As per Sub-Rule 2, disciplinary authority is required to frame definite charges on the basis of allegations on which the inquiry is proposed. The charges must be supported by a statement of allegations along with list of documents and list of witnesses by which the charges are proposed to be sustained. After the government servant submits his written statement, the disciplinary authority may himself inquire into charges which are not admitted or may appoint an inquiry officer to conduct inquiry. In the inquiry conducted by the inquiry officer, the disciplinary authority may nominate a presenting officer to present the case of the disciplinary authority. The government servant may present his own case with the assistance of other government servant with the approval of the disciplinary authority. The inquiry officer in the course of the inquiry may take into consideration all documentary and oral evidence adduced and thereafter record his findings on the charges. On conclusion of the inquiry, he shall forward his findings on each of the charges together with the reasons therefore to the disciplinary authority. Disciplinary authority shall consider the record of the inquiry and record his findings on each charge. The disciplinary authority shall furnish a copy of the inquiry report to the government servant and after considering the response of the government servant may impose such penalty as may be deemed fit and proper in case of both major and minor penalties. Sub-Rule 12, now this is what I am relying upon. Sub-Rule 12 is relevant for the purpose of present case and is extracted hereunder. Notwithstanding anything contained in this rule, it shall not be necessary to follow the procedure laid down in preceding sub-rules in cases where it appears to the authority competent to impose the penalty at the initial stage of the proceedings that penalty of censure would be adequate. But if at any later stage, it is proposed to impose any other penalty specified in Rule 7, the procedure laid down in the said rules shall be followed. No order imposing the penalty of censure shall, however, be passed except after the government servant is informed in writing of the proposal to take action against him and of the allegations on which it is proposed to be taken and given an opportunity to make any representation he may wish to make, and such representation, if any, is taken into consideration by the disciplinary authority. A perusal of Sub-Rule 12 of Rule 9 would go to show that the procedure prescribed under Rule 9 may not be followed if the disciplinary authority takes the view at the initial stage that penalty of censure would be adequate, but if at a subsequent stage, the disciplinary authority takes the view that imposition of other penalty would be justified. The procedure laid down in Rule 9 would then have to be followed. Even in case of imposition of the penalty of censure, the government servant would have to be informed in writing that imposition of penalty of censure is proposed against him on the allegations, and the government servant should be given an opportunity to make any representation if he wishes to do so. On consideration of such representation, the disciplinary authority may impose the penalty of censure. From a careful analysis of the provisions laid down in Rule 9 of the 1964 rules, it is evident that for imposition of any penalty mentioned in Rule 7 of the 1964 rules, be it minor or major, except the penalty of censure, the procedure prescribed in Rule 9 would have to be followed. Before imposition of penalty, holding of inquiry is mandatory. Such inquiry is quasi judicial in character. Rule 9, which includes holding of inquiry, lays down a fair procedure encompassing therein the principles of natural justice. This court has held in the cantina of judgments that the procedure prescribed in Rule 9 is of mandatory character, and non-compliance to such procedure would vitiate the departmental proceedings drawn up against the servant. Insofar as imposition of penalty of censure is concerned, the government servant would have to be put on notice by the disciplinary authority at the threshold that on the basis of the allegations, the disciplinary authority proposes to impose the penalty of censure and to seek his response. After the government servant submits his response, the same is required to be considered by the disciplinary authority, whereafter the penalty of censure may be imposed if considered necessary. At this stage, a brief reference to Rule 7 may be made. Rule 7 mentions that penalties which may be imposed on a government servant, starting from censure to dismissal from service. It is seen that both censure and withholding of increment or promotion are distinct and separate penalties. As noticed above, the show cause notice was issued under Rule 9 of 1964 rules read with 311 of the Constitution of India, as in my case.
You go ahead with the whole thing, but this position is the same that I indicated.
My lord,
For censure, there is no need to give reasons, there is no need to, because censure cannot cause prejudice to your clients in any manner.
my lord, provided this.
They cannot deny you promotion on the basis of censure. Where
They
is the
cannot.
judgment?
They cannot. My lord, Janki
Where is
Raman-
the judgment?
Janki Raman, my lord.
Show it
Yes.
to me. That is the whole matter.
Yes,
There is
my
no point here going.
I completely bow down.
There is nothing else in your case. Mr. Nayak, you can't do that. If you have imposed censure, that seal cover proceeding now has to be given effect to. And if he is otherwise considered and found fit, he has to be promoted.
In
That's the
Janki
law.
Raman is a specific case, lordship. There are certain conditions are there. If those conditions are not fulfilled, then the recommendations of DPC cannot be put under seal cover. That is the law, lordship. But in this case, lordship, before the DPC, one enquiry report was already there.
That enquiry report is of no consequence. The only enquiry which will be relevant for him is an enquiry under Rule 9 of the Assam Service and Discipline. No other enquiry.
Janki Raman doesn't say so, lord.
No, Janki Raman.
Janki Raman, lordship will get only one inquiry. Here, lordship, one inquiry was already there. In terms of, in that inquiry, lordship, a
That
specific,
enquiry was under which provision of rule?
it was a officer's inquiry, lordship. It was,
What officer, which provision of the rule permits?
no, it was not under rule, lordship.
Then it will not be taken account. See, Mr. Nayak, these things are very firmly percolated and crystallized by now. You can deny him promotion if there is an order of penalty which permits that.
Lordship.
Otherwise, the departmental proceeding is the only proceeding which can come in the way of consideration, or if there is a consideration in a seal cover of any candidate's right to be considered for promotion. In that also, if it is a censure, then there is no need for the department to hold an inquiry by appointing an inquiry officer and record any finding.
Lordship,
Because-
just one lordship, inquiry, that imposition of censure, lordship, was subsequent to issuance of the so cause notice, and proper inquiry report was there. Only after that penalty was imposed, lordship. It is not that so cause was not issued.
No, so it is censure ultimately. The proceeding has been closed.
Yes, that for that, lordship, one OM is there, lordship. In that OM, it has been clearly.
Mr. Nayak, you have not seen the language of that letter. That it says we are closing the DP. DP is never closed. DP ultimately ends in an inquiry report where either the charge is proved or not proved. Here, the question of proving the charge does not arise because the authorities did not go ahead with that. They closed the proceeding. Have a look at page 97. Have a look at 97. See, please read the last paragraph. Can you please read out the last paragraph?
My lord. Now, therefore, after careful examination of all aspects, the departmental proceeding drawn as against Sri Hiten Kalita, so and so, by show cause notice 6th April 22 is hereby closed by imposing a penalty of censure.
So DP was closed, dropped. Closed means dropped.
No, if it should have been dropped, lordship, that penalty was not have
Alright,
been
we'll
imposed.
clarify it. It is closed. Closed means there was no DP in the sense that the charges were not pursued against him. So whatever, whether he is right or wrong, the authorities Censure means what? It's some kind of a stricture. That cannot take away the right to be promoted of any employee. That's the law.
No, we'll consider him lordship. Yeah,
No,
even
no,
lordship, I am informing your lordship, even at this stage, lordship, another so cause notice was issued to him. Lordship, it is pursuant to a work that was going on in Nagaon, lordship, but bridge under construction collapse, lordship. It was under his supervision. This is another so cause, he is another DP is going on against him.
This is.
So he is the same person,
September 21,
lordship.
my lord. The invocation of seal cover procedure happened in September 21 on the false
Is
pretext.
there
my lord.
another departmental proceeding?
Right
Now,
now
so
also,
cause
Lord.
notice has been issued now, my lord.
This is another departmental proceeding.
But where is it? This is not a part of this.
No, my lord, this because we are participating in that, my lord.
No,
But
then
with
without
greatest-
knowing what is the matter, there no order can be passed here.
My lord, with the
You should
greatest
have- you
respect,
should
my
have
lord.
told it in the beginning.
No, my lord, this has show cause notice has been issued, my lord, and we are participating in that. It is not their case even. my
No,
lord.
then the court has to pass an order subject to outcome of this DP. His case will be considered in this manner. How can a mandamus be issued like that?
My lord, with the greatest respect, what I'm trying, my lord, Janki Raman and this case, my lord, says that you have to consider the relevant date, my lord, when the promotion happened, my lord, of the colleagues. Now, my lord, your lordship, in the recent judgment of Union of India versus Anil Kumar Sarkar, they say that if on the date when the promotion is given to the colleagues, my lord, the juniors, then on that day, whether there is a show cause notice, whether there is a disciplinary proceeding initiated, whether there is an order of suspension, and whether there is a criminal proceeding pending, my lord, that is all that has to be
So
seen.
which is the day when the juniors were promoted?
My lord, in November 21, my lord. My lord, 22nd November 21, that your lordship will find at page 44, 46 of WPC, my lord, 356.
This is the problem. I will not go on opening 2-3 different briefs. Whatever you can show from this, show. Rest of it.
My lord, this date your lordship wanted to know, my lord, 22nd November 21, my lord, is the date when the petitioners' colleagues were promoted, my lord.
Twenty-seven.
22nd November 2021, my lord.
And the departmental proceeding was initiated on 6th of April 2021.
6th April 22, my lord.
22, that's right.
22, yes.
So Janki Raman comes into your rescue.
Yes, my lord. Janki Raman, as well as a long line of judgments. My lord, 2013, my lord, there was a judgment which was, my lord, which arose from a decision of this honorable court, my lord, which was upheld by the honorable Supreme Court in Union of India versus Anil Kumar Sarkar, my lord. Lord, I have enclosed it. I have given the SCC copy also, my lord, now.
Yeah, just a minute. So your case has been considered and kept in a seal cover along with your juniors. But you don't know what is the outcome of that process.
No, because I was selected. The select list had my name, my lord. That your lordship will find. I'm so sorry, my lord, because those papers your lordship will find in the other petition.
No, will not.
Well,
You should have
I'll-
prepared one bunch.
Well,
You
I'll
can't ask the court from jump from one case to another.
well, may have then WPC 448,
Yes, that is the only proceeding I am
my lord.
going to look at. Yes.
Page, my lord. My lord, page 21 to 22, my lord, I'm so sorry, my lord, of 356, my lord. 21 to 22. My lord, will notice at the very top, my lord, of page 21, minutes of selection board meeting for selection of officers for PWD for promotion to the rank of superintending engineer.
These matters would have been thrown out only on these grounds, Mr. Fuku.
My lord,
You should have come up with a consolidated. Yes, which page?
My lord, page 21, my lord, the very top. In fact, your lordship acknowledged this because in the various orders, your lordships had indicated in the beginning also that it can be disposed of at the stage of admission. Minutes of selection board meeting for selection of officers for PWD for promotion to the rank of superintending engineer from executive engineer held on 28th September 2021 at 11 AM in the office of so-and-so. Your lordship may come to page 22. My lord, C. Officers recommended for promotion against 8 posts to be created newly for the newly created circles under PWD as per approval of the Honorable Cabinet meeting held on 26th August 21, subject to sanction of creation of the said posts. My lord, I find mention, my lord, at serial number 6, my lord. 26, my lord. In fact, I had the best NCR ratings also, my lord, at that point. The selection board advised not to issue posting orders by PWRD for the above 8 officers till post creation letter to the is issued after observing all formalities. The selection board further decided to keep the decision of the board in respect of Sri Hitan Kalita, executive engineer, that is me, my lord, for promotion to next higher rank of superintending engineer against the roster point 54 under seal cover till resolving the adverse report received from the additional chief secretary to the government of Assam Department of Housing and Urban.
Cover here. Everybody knows that he is recommended and then seal cover. What is there in the seal cover?
Lordship, if he subsequently promoted lordship.
No, he will be promoted now. But what I am asking is, you declare that he is recommended and then say that it is in seal cover. It seems nobody in the government knows anything about law. Rules,
In fact, I am also surprised. Lordship.
and then
If it
they
is-
ask you to make arguments before
If
the
it is
court. And
notified,
you end up making all sorts of arguments.
no, they could have write that he has,
Where is
this
the
case
seal
has been
cover?
considered and.
He has
still
been
covered.
considered, he has to be now promoted.
Yes.
As simple as that. There is no point. You see, what happens is unnecessary arguing is nothing but just consuming the court's time.
Just
That
one
is
line,
what
just
makes
one
us
line,
irritated.
one line. Now, rightly or wrongly, lordship, one.
No, first of all, there is no seal cover here. The committee which has expressed seal cover looks like didn't know the meaning of seal cover. When it is kept in seal cover, that means the outcome is not known. Whether the candidate is recommended or not, nobody knows.
Lordship.
But now he has been recommended, it's there out in the open.
Yes, that.
And they say that we keep it in seal cover.
Lordship will see the last paragraph of that page 22, lordship.
Page 22.
Yes. That same repetition, lordship. The selection board further decided to keep decision of the board in respect of Sri Hitan Kalita, executive engineer, for promotion to the next higher rank of superintendent engineer against the roster point number so-and-so under seal cover till resolving the adverse report received from the additional chief secretary to the government of Assam Department of Housing and Urban Affairs by letter number so-and-so dated 22/9/2021 against him by the Public Works Department. So it was only kept in abeyance, lordship, that kind of.
That's it. What else?
Lordship, one
And
notification.
and another thing is, the only way you can initiate a proceeding against a government employee, government servant, is as per the Assam Service Discipline and Appeal Rules, Rule 9. Who is the urban department? They can make all kinds of recommendations. But the proceeding were initiated. He was served with a statement of allegation. Then, or after this reply is submitted, the department decides not to hold a full-fledged inquiry and close the matter by imposing penalty of censure. Censure can be imposed as per sub-rule 12 without following the procedure in rule 9. That is the end of the matter. You have to now give him promotion and give him seniority with effect from the date on which juniors were promoted. If both of you take your seat, I can dictate the order. There's nothing else to argue
Just
here.
one line, lordship, one penalty is there, censure is there, just one paragraph I am showing, lordship, in that OM of 1980 something, lordship. It's set for
And give the decision of Janki.
Well, I have handed over, my lord, Janki Raman, my lord, as well as Anil Sarkar.
Janki Raman, which is the paragraph? Para?
No, I'll just tell them.
Oh,
Para
this
six,
thing-
para 16 Miller. In fact, they take note of Miller preliminary investigation. That preliminary investigation, even if it is pending, that is not a ground for
No,
Miller.
no other investigation.
Para 16 Miller.
And where is Anil Kumar Sarkar?
My lord,
Mr. Nayak, the court is not trying to shut you out on arguments, but all I'm trying to point out is there's no point arguing against settled law.
Lordship.
It is just sheer wastage of time. If you want to say that there is some other point involved here, what you are saying is against settled law. What do you want the court to hear on? You are saying somebody else, some other department is inquiring, so you can't do that way. Even if, let's take it that is correct. We'll clarify that it cannot be done. Even if they find him guilty, then also it cannot be done. Forget inquiry. Because the only way a government employee can be penalized is if an inquiry is held under Rule 9. No other way. Or if there is a criminal proceeding where he has been charged and charge has been proved. There is no third way. You may do whatever you feel like. It will not work.
Lordship will then keep one way open for me, Lordship. So far as the second DP is concerned, that is going on now.
Second
Lordship.
DP for subsequent promotion, not superintendent engineer.
Lordship will clarify.
That will clarify.
Lordship. That he
That
has-
promotion has to be given to him. If you are serious and if there was a real, and what is the allegation? There was a budget of 2 crores and he prepared an estimate of 1 crore 94 lakhs.
That was
And which was again exposed for.
that amount was spent without any approval of the
That
government.
approval came later on
That
exposed. to-
subsequently came.
before
Then-
issuance of show cause notice.
Then, if the approval has come, then what is wrong about it? How can you, what penalty you want to dismiss him from service?
No, that is
Then-
not there.
These are just vilification, nothing else.
Then on my submission, Lordship, 2 issues are here, Lordship. One is silk proceeding and second is imposition of penalty, Lordship. Lordship, I hope Lordship will not interfere in the second case, Lordship, so far as imposition of penalty is concerned. That was
No,
pursuant to a DP.
no, that is censure.
Yes, Lordship. That will remain,
We
Lordship.
will not interfere with that.
Lordship.
But that cannot be a ground to deny him promotion. Pursuant to the minutes of the selection committee of,
Yes, that is there, Lordship.
That will
because
clarify.
DPC was prior to the imposition
Yes,
of censure, Lordship.
yes.
That is there.
so he cannot be denied promotion.
But Lordship will only record my submission that prior to the DPC meeting, one inquiry was there. And the additional secretary of that department instructed the personnel department not to promote him in the DPC, Lordship. That was prior, Lordship.
But you want me to go into
Lordship,
it that
Lordship,
way,
Lordship.
I can then the strictures will follow. How
Lordship
can
will
the
Lordship will just
instruction be
record that statement, nothing else, Lordship.
not to promote? That means there is a personal, in fact, you're lucky that he has not made that person a party. How can he issue such instructions?
Lordship, I'll leave it to your Lordship. Lordship will just give
See,
that.
the government machinery has to go as per the rule of law. Otherwise, it throws up questions which will be very embarrassing for the court to go into.
Lordship, I'll leave it to your Lordship. Lordship will only give me the liberty.
Department, the coordinate department have every right to flag if there is any anomaly.
Lordship.
But what should be done to him is the prerogative of the administrative department. Only on that ground, the whole proceeding can be quashed.
Lordship,
Some other secretary cannot suggest what is to be done to him.
Lordship.
They can say that in this work, there were some anomalies and these are the involvements of X, Y, Z. Please take note of it and consider it.
Lordship, I vote on to your Lordship, but only that.
Beyond
prayer,
that,
Lordship.
can anybody say, can the Home Department secretary say, you You penalize someone in the veterinary
Yes,
department
yes,
because
I-
I don't like his face.
I agree, Lordship. But Lordship will not, I'm praying Lordship will not interfere with the censure. And secondly, Lordship will give me the liberty to take whatever action department wants to take pursuant to the second DPC Lordship. I mean, second DPC.
DPC, I have, there
Second
is
DP
no
law.
observation here. That is not before the court.
And they have not mentioned anything, Miller.
It's not because this is all oral submission.
Lordship.
Second DP, you go ahead, but that cannot come in the way of.
That one line only, Lordship. Otherwise,
Miller, even the constitution of that inquiry by Department of Housing and Affairs was vitiated on the face of it, Miller, because the Director Town and Country Planning had an obligation. He in fact corrected such deviation in implementation of a project in Dibrugarh.
Where is Anil Sarkar?
Miller, Anil Sarkar, I've just handed over. Miller, the discussion starts from paragraph 11. Miller, the relevant paras, according to me, Miller. I handed over one more copy, Miller.
No, just a minute, it will be there. Is that there? Yes.
Miller, the discussion starts from paragraph 11. Miller, the relevant paragraph according to me would be paragraph 14, Miller. 14, 15, 16, they discuss Janki Raman also, Miller.
So what is the ratio here? Can you please point out?
Miller, the ratio here, according to me, is that, Miller, the relevant date, Miller, when the colleagues are promoted, on that date, Miller, the court will have to see whether there is a Ashoka.
Which paragraph?
My lord. Paragraph 14, Miller, paragraph 14. As per para 2 of the same memorandum is also extracted, Miller, at paragraph 11. At the time of registration of the government servants for promotion, the following details of government servants in the consideration zone for promotion falling in the categories mentioned should be specifically brought to the notice of the DPC, namely, government servant is under suspension, government servant has been served with a charge sheet, and the disciplinary proceedings are pending. And 3, government servant is facing prosecution for a criminal charge, and the said proceedings are pending. As rightly observed by the High Court, if the above conditions are available, even one of them, then the DPC has to apply the seal cover procedure. In the case on hand, it is not in dispute that the relevant date, that is 21st April 2003, when the respondents' batchmates were promoted, admittedly on that date, the respondent was not under suspension, no charge sheet was served upon him, nor was he facing any criminal prosecution. In such circumstances, in terms of para 2 referred to above, the recommendation of DPC has to be honored, and there is no question of applying seal cover procedure. My lord, this relevant date in my case, my lord, your lordship will find it page 44. Your lordship had put this query to me, my lord. Page 44 is the relevant date, and that is 22nd November 2021.
That's right. And this judgment has considered
Janki Raman is considered, Milan, at paragraph 16 and 17.
KV Janki Raman is the first decision on that point.
On that point, yes.
All right. So that's it. Take your seat then. Yes.
Milan, on the point of minor
So you want to argue?
No, I don't want to. Milan. All that I'm saying is because it is based entirely on an inquiry conducted by the Ministry of Housing and Urban Affairs, and the constitution of that committee itself is vitiated because there was one of the members, Milan, is director.
Mr. Fukan, now I'm having the tendency of admitting your petition and posting it for hearing.
Milan, I'm bowed on. I completely bowed on.
Don't go into unnecessary area. But no interference, censure. Censure is the prerogative of the employer.
Right.
Court will not come into it. That is why no procedure is prescribed for censure.
Milan.
Penalties can be attacked only on the ground of procedural violation.
My lord.
In censure, no procedure is prescribed.
My lord.
Rule 9 is not applicable at all. You have seen it due to sub rule 12. So therefore, censure, you cannot complain. This is like giving a dhamki. Be careful. That every employer will always be entitled to do. Every senior will be entitled to do to his junior, though it is not recommended. I'm not talking about senior in advocate seniors,
my lord.
any senior anyway. So this is something the courts cannot interfere with. But although it is it is considered as a minor penalty,
My lord.
but this penalty does not cause any prejudice to the employee in any manner.
My lord may say so, I'll. About.
Or I take down heard Mr. A.K. Fukan, A. Fukan, is it?
A Fukan, my lord.
A. Fukan, learned counsel appearing for the writ petitioner. In both these writ petition also heard Mr. P. Nayak, learned standing counsel PWD Assam appearing for the respondent numbers.
One. Lordship, I'm appearing for 1, 2, 3, 4, Lordship.
1, 2, 3, 4. Mr. D. Bora, learned government advocate Assam, has appeared for the remaining respondent.
5 and 6.
Respondents, that is, has appeared for respondent numbers 5 and 6. Full stop. Both these writ petitions filed by the same petitioner arise out of more or less common factual background and are interconnected with each other. Therefore, I propose to dispose of these writ petitions by these writ petitions by this common judgment and order. Full stop. The writ petitioner herein is serving as an executive engineer under the PWD, Public Works Department, PWD Assam. Full stop. Presently, he is posted at, where is he posted?
Nagaon, my lord.
At Nagaon, and in the Nagaon division of
Yes.
PWD. Full stop. Aggrieved by denial of promotion to the post of superintendent engineer, the petitioner has approached this court. Aggrieved by denial of promotion to the post of superintendent engineer, and also the seal cover within courts, seal cover proceeding adopted by the selection committee. The petitioner has approached this court by filing the instant writ petition. Full stop. The petitioner's case, in a nutshell, is that while working as executive engineer PWD Nagaon, he was supervising the additional work of within courts, improvement of Nehru Bali ground, including walking and cycle track, and development of Lakhi Prasad Goswami open stage at Nagaon. Full stop. Full stop. Although the PWD was the nodal agency for execution of the work, the project was under the aegis of the Department of Housing and Urban
Affairs.
Affairs. Full stop. Full stop. The city level implementation and monitoring committee bracket CIMC bracket close was monitoring the work. Full stop. However, after execution of the work, the Housing and Urban Affairs Department had come up with an allegation that the petitioner had prepared the estimate for the work without obtaining the approval of the administrative department. Full stop. Consequently, some inquiry was conducted by the Department of Housing and Urban Affairs, whereafter the additional chief secretary of the concerned department had made a recommendation that the petitioner should not be promoted to the post of superintendent engineer. Full stop. It was around that time the departmental promotion committee was considering the candidature of a number of candidates in the post of executive engineer for promotion to the next higher post of superintendent engineer. Full stop. Taking note of such objection raised by the Department of Housing and Urban Affairs, the Special Commissioner and Secretary, Public Works, bracket Roads, bracket close, Department, Dispur, had served a show cause notice dated 6/4/2022, calling upon the petitioner to submit his response with regard to the allegations brought against him. First up, the allegations leveled against the petitioner as apparent from the statement of allegations is reproduced herein below for ready reference. You'll get it in page 92, double tick to double tick. Page 92 of WPC number 448 of 2023. On receipt of the show cause notice, the petitioner had submitted his reply by explaining his stand. Full stop. After taking note of the reply submitted by the petitioner, the Special Commissioner to the Government of Assam, Public Works Road Department had issued notification dated 1/7/2022, closing the departmental proceeding drawn against the petitioner by imposing the penalty of within quotes censure, 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 comma, full stop. It appears that on 28/9/2021, the selection board of the PWD had met and recommended the names of met and considered the candidature of a number of departmental candidates for promotion to the rank of superintendent engineer. Full stop. In the said DPC meeting, the names of as many as 8 executive engineers were also recommended for being promoted to the newly created posts of superintendent engineer. Full stop. In the list of the aforesaid 8 officers, the name of the writ petitioner finds place in serial number 6. Full stop. The selection board has, however, observed that the case of the writ petitioner be kept in within quote seal cover until such time the adverse report received from the additional chief secretary to the Government of Assam, Department of Housing and Urban Affairs, via letter dated 22/9/2021, is resolved by the Public Works Department. Full stop. Consequently, although persons junior to the writ petitioner were promoted to the rank of superintendent engineer on 22/11/2021, his case has been kept in seal cover, within for seal cover, in the manner indicated above. Full stop. Aggrieved by the aforesaid decision of the DPC to keep the case of the petitioner in seal cover, WPC number 356/2023 has been filed. Full stop. During the pendency of the aforesaid writ petition, the order dated 0107/2022, imposing the penalty of within court censure bracket close was issued by the authorities, full stop. Therefore, comma, the subsequent writ petition being WPC number 448/2023 was instituted by the petitioner, full stop. Next para. By referring to the materials available on record, Mr. Phukar submits that since the show cause notice, memorandum of charge served upon the petitioner on 6/4/2022, envisaged imposition of major penalty. Hence, it was not open for the respondents to subsequently impose the minor penalty of censure upon the petitioner. First time. It is also the submission of Mr. Phukar that on the date of consideration of the candidature of the eligible departmental candidates for promotion to the rank of superintendent engineer, including the writ petitioner, that is on 28/09/2021, there was neither any departmental proceeding pending against the petitioner, nor was he involved in any pending criminal proceeding. Therefore, in view of the law laid down by the Honorable Supreme Court in the case of Union of India and others versus K full stop V full stop Janaki Raman and others, reported in 1991 bracket close 4 SCC 109, as well as the subsequent decision rendered in the case of Union of India and others versus Anil Kumar Sarkar, reported in 2013 bracket close 4 SCC 161. The respondents could neither have kept the consideration made to the petitioner for promotion in a seal cover, nor could he have been denied promotion to the rank of superintendent engineer. Full stop. Responding to the above, Mr. Nayak, Learned Standing Council, PWD, submits that although the departmental proceeding was initiated against the petitioner subsequent to the holding of the DPC on
6/4 lots, 6/4/2020.
no, DPC was not hung. On 28, on
Nine.
28/9/2021. Yet, on that date, the Department of Housing and Urban Affairs had conducted an inquiry, and there was instructions from the additional chief secretary of the HNUA department not to promote the petitioner to the rank of superintendent engineer. First off, it was on such count that the case of the petitioner was kept in a seal cover. Full stop. Mr. Nayak has further submitted that even thereafter, another departmental proceeding was initiated against the petitioner by memorandum of charge dated
12 April 2023.
12/4/2023,
Got it.
pertaining to another incident of bridge collapse at Nagaon, and therefore it cannot be said that the petitioner has been completely exonerated from allegations of misconduct. Full stop. It is on such ground Mr. Nayak has resisted the prayer made in both the writ petitions. Full stop. Mr. D. Bora, learned government advocate Assam, has adopted the arguments made by Ilan Standing Council, PWD Assam. I have considered the submissions made at the bar and have gone through the materials available on record. First up, the first point urged by the petitioner's counsel in this case is to the effect that the authorities could not have imposed the penalty of censure upon his client without upon his client in view of the allegations brought in in the show cause notice dated 6/4/2022. First up, it may be noted herein that Rule 9 of the Assam Service Discipline and Appeal, bracket or Discipline and Appeal, Rules 1964, lays down the procedure to be followed for imposing penalties upon a public servant in employment of Government of Assam. First up. Sub-rule 12 of Rule 9, however, makes an exception in case the penalty sought to be imposed is within quotes censure. Full stop. Sub-rule 12 of Rule 9 is reproduced herein below. 12, no, it will be 12A, small a. Is reproduced herein below for ready reference. So you get it here. Get it here. In the present case, there is no doubt or dispute about the fact that the order of penalty of censure, within quotes censure, was imposed upon the petitioner after giving him an opportunity, after informing him about the proposal to take action against him on the allegations, and also after giving him an opportunity of making a representation. First up, a reading of the order of censure dated 1/7/2022 also goes to show that the explanation furnished by the petitioner has also been taken note of by the departmental authorities. First up. First up. On a careful examination of the materials available on record, I do not find any justifiable ground to interfere with the order of penalty dated 1/7/2022. Full stop. Next paragraph. Insofar as the other grievance of the petitioner pertaining to keeping his candidature in seal cover, what is to be noted here in that as on 28/9/2021, that is the date on which the selection committee has made the recommendations for promotion of several departmental candidates, including the petitioner, to the rank of superintendent engineer. Now, what is to be noted here is that as has been mentioned above, on the date of so-and-so, there was no departmental proceeding pending against the petitioner. Full stop. It is no doubt correct that materials on record indicates that some inquiry was going on in the Department of Housing and Urban Affairs. But what is significant to note here in that the only inquiry, the only departmental, no, the only inquiry that is contemplated under the law against a government servant in employment of Assam government is as prescribed under Rule 9 of the Assam Service Discipline and Appeal Rules 1964. And there is no dispute about the fact that the inquiry allegedly conducted by the Housing and Urban Affairs Department was not one coming within the ambit of Rule 9 of the rules of 1964. As a matter of fact, the inquiry, the proceedings initiated against the petitioner under Rule 9 of the rules of 1964 was by serving the show cause notice dated 6/4/2022, which culminated in the order dated 1/7/2022, imposing the minor penalty of censure. Full stop. Censure. Therefore, there can be no doubt about the fact that on the date of holding the DPC stroke selection committee meeting, that is 28/9/2021, there was no departmental proceeding pending against the petitioner. Full stop. In the case of KV Janaki Raman, bracket Supra, the Supreme Court has categorically held that it is only when a charge memo in a disciplinary proceeding or a charge sheet in a criminal prosecution is issued to the employee that it can be said that the departmental proceedings stroke criminal prosecution is initiated against the employee. Stop. The seal cover procedure is to be resorted to only after the charge memo or charge sheet is issued. Stop. The pendency of preliminary investigation prior to that stage will not be sufficient to enable the authorities to adopt the seal cover procedure. Full stop. Next. By relying on the decision of KV Janaki Raman Supra, the Supreme Court has categorically held in the subsequent decision rendered in the case of Anil Kumar Sarkar as follows. Here you quote para 14. Quote para 14 of Anil Kumar Sarkar. From a careful analysis of the ratio laid down in the aforementioned two decisions, it is apparent that merely because there was some interdepartmental stroke in-house inquiry going on against the petitioner, this same would not have been a ground. Interdepartmental preliminary inquiry going on against the petitioner, the same could not have been a ground for the authorities to resort to seal cover proceeding. Moreover, from a bare reading of the minutes of the proceeding dated 28/9/2021 goes to show that the DPC has already disclosed about the fact that the petitioner's case has been recommended for promotion to the post of superintendent engineer. Full stop. Therefore, there was hardly any scope of having a seal cover proceeding in this case, as has been projected in the minutes dated 28/9/2021. Be that as it may, for the reasons discussed above, this court is of the unhesitant opinion that there was no justifiable ground for the respondents to withhold the promotion of the petitioner on the basis of recommendation of the selection committee made on 28/9/2021 by showing his case in within quotes seal cover, full stop. The mere fact that there has been a censure imposed upon the petitioner cannot in any way denude him of his right to be promoted to the next higher rank on the basis of recommendations made by the selection committee. Full stop. Full stop. For the reasons stated herein above, WPC number 448/2000. WPC number 356/2023 succeeds. The respondents are directed to forthwith give effect to the recommendation of the selection committee dated 28/9/2021 by promoting the petitioner to the rank of superintending engineer in the PWD department by giving him seniority with effect from the date on which his juniors were promoted as superintending engineer. Full stop. Appropriate notification on that behalf shall be issued as expeditiously as possible, but not later than 2 weeks from the date of receipt of a certified copy of this order. Full stop. Insofar as the submission made by Mr. Nayak pertaining to other departmental proceeding initiated against the petitioner at a subsequent stage, it is made clear that the authorities would be at liberty to proceed with the matter in accordance with law. However, the departmental proceeding initiated against the petitioner by memorandum dated, what is the date you said?
12 April 2023.
12 April 2023 shall not have any bearing on the question of implementation of the recommendation of the selection board dated 28/9/2021 and therefore would not come in the way of issuance of notification of the order of promotion of the petitioner to the rank of superintendent engineer. Full stop. For the reasons stated herein above. Full stop. No, again. In the light of observations made herein above, WPC number 448/2023 stands disposed of. Parties to bear their own cost.
Deeply obliged.
Anything else to be added?
Deeply obliged.
Obliged.
Yes.
May I please, your lordship? My lord, this petitioner was, my lord, employee of State Bank, my lord. And my lord, in this case, my lord, legality and validity of my lord, penalty of dismissal is under challenge, my lord. And this penalty was imposed in the year 2018, my lord. And my lord, initially, my lord, charge sheet was issued in the year 2012. And thereafter, my lord, departmental proceeding was concluded in the year 2013. And at that point, my lord, he wanted to examine one, my lord, defense witness, my lord. That was denied. And challenging that, my lord, he filed a writ petition in the year 2014. And that writ petition was allowed. And my lord, there was a direction to, my lord, continue departmental proceeding from the stage of, my lord, examination of that defense witness. And my lord, pursuant to that order of honorable court, my lord, again, my lord, departmental proceeding was initiated from examination of that witness, my lord, defense witness. And my lord, thereafter, my lord, again, they have examined two other witnesses, my lord. without notifying my lord, the petitioner, and my lord, 2 exhibits was also taken into consideration. And most importantly, my lord,
All right, now, do you have a written argument or something, written note?
no, my lord.
When you do that, I'll dictate judgments in court. And what is your response to this?
My lord, earlier case was for not giving opportunity of hearing by not allowing the defense witness, whose name was my lord
Horeshwar
Rajbangshi. In that repetition, your lordship said pleased to hold that he should be examined. From that onwards, lordship, the further inquiry was earlier disciplinary proceeding. That means the inquiry report as well as findings of the appellate court, those have been lordship set aside by this honorable court. Subsequently, what
Where is
happens?
the judgment?
Judgment
At my lord, annexer, my lord, 14 at page 87, my lord.
Page 87.
87.
Yes, lordship. Lordship, running page 89, para 1, 2, 3, 4th para, lordship.
So it is a very the disciplinary proceeding to continue from the stage of examination of Horeshwar Rajbangshi. Then what happened?
Then they have examined 2 other witnesses. Their witnesses, my lord. And my lord, most surprisingly, my lord, now in the, my lord.
Who are the 2
affidavit-
witnesses? What are their names?
My lord. One is my lord Diganto Rabha.
So this will require full-fledged hearing.
Yes,
Please come up
full-fledged
with a
hearing.
note.
We can-
Come up with a note. Records will be necessary, no?
Records will be
Inquiry proceeding, they have submitted copies, lordship, the inquiry report. Nextly, lordship, my humble submission will be that matters pertain to period 2008 to 10. Meanwhile, this period has elapsed. My
And
lord,
is he still has, if he succeeds, he can get reinstatement or he has attained
He
the.
has already attained his.
So what is the relief you can get now?
My lord, at least my lord, back wages, or if my lord.
Back wages,
It is set aside, my lord. And my lord, his pensionary benefits also, my lord.
Penalty is what? Removal.
Dismissal.
Dismissal.
And which judgments you are relying for relief? Which are the judgments for relief you are relying?
My lord, that I will have to say, because my lord, he has been deprived from examining that 2 witness, my lord. And also they have taken into record 1 letter purportedly issued by my lord, that defense witness, who has retracted from his earlier statement. And that was, my lord, only submitted along with, my lord, their affidavit in opposition, my lord.
So then you prepare and come,
My lord.
then we'll see. When do you want it? Both of you agree?
Lordship, after summer vacation, my lord, if your lordship is pleased to hear the matter entirely.
Yes.
Yes,
No,
in the
after
month of
summer
July.
vacation.
Yes.
All right, heard Mr. S.
Month of July.
This petitioner also heard Mr. Ankaluzal and counsel appearing for the respondent bank respondents stroke bank. First up, after hearing the preliminary arguments this court is of the opinion that this matter will be, this matter has to be taken up for final hearing and disposal at an early date. As such, issue rule making the same returnable on 20th of July, 20th of July.
20 lordship.
July 2023. Since the respondents are already represented, no formal notice. Registered to list this matter for hearing again on 27/2023.
All right.
Yes. All the next matter, what is it?
May I please, ma'am? My lord, again, a case wherein, my lord, my promotion was denied to me because of a pendency of a complaint case against me. My lord.
Are you
But
ready for disposal?
yes, your lordship.
Ready?
But yesterday they
I
had,
have to just find one judgment
my
regarding.
lord, they had filed an affidavit
I
yesterday.
Pray for just 1 day's time. If it can be fixed on Tuesday, your lordship.
They have filed an
Monday,
affidavit
Monday,
also.
don't give time. Thursday, next
Thursday.
Thursday. then.
Lordship.
Heard Mr. Yukana, Learned Senior Counsel appearing for the petitioner on the request of Mr. D. Bora, Learned Government Advocate Assam. This matter is directed to be listed again on 1st of June,
First of
1st of June,
Lordship.
2023. As a-
Five also same.
Sorry,
Five also, my lord, promotion, same, my lord, with regard to a departmental post. That matter, my lord, wherein the CGM had sent back the May I please, my lord? My lord, the petitioner, while working as, my lord, an assistant engineer, as an executive engineer, there was an FIR lodged against him. That FIR culminated in a charge sheet in 2017. Then, my lord, summons were issued to us. Thereafter, my lord, the CGM found that there are serious flaws in that charge sheet. And, my lord, he sent it back for reinvestigation. The matter went back to the police. The police then, my lord, started reinvestigation. In the meantime, my lord, there was a promotional exercise in my department, 2001. My case was kept in seal cover. And in 22, my lord, the fresh charge sheet was issued, was submitted without reference to, my lord, the earlier charge. So, my lord, the law is clear. My lord, it should be a further investigation, but here it was reinvestigation. For my purpose, my lord, for bringing in the concept of Janaki Raman, my lord, Janaki Raman says if there is a charge sheet pending either in a criminal or in a, my lord, departmental proceeding, then the matter has to go to a seal cover, my lord. The proceedings has to go to a seal cover. But here, my lord, because of that order of the Honorable CJN, there was no charge sheet, my lord, because that charge sheet was not acted upon, and a fresh charge sheet came in 2022. In that view of the matter, my lord, my case could not have been kept under seal cover. It should have been, I should have been promoted. That's my lord, limited case. Now, interestingly, they are also waiting for my promotion because in the gradation list of executive engineer, they have incorporated my name and they have said it's under seal cover. If I may just have my lord's attention to the promotion order that my lord would find at page 24, 28/6/2021. This is, my lord, my batchmates and juniors were promoted as executive engineer. Then, my lord, page 36 is the gradation list, 4/2/22, my lord. Here, my lord would find at page 37, serial number 70, my lord. Prashna Brahma, serial number 70, STP, seal cover.
what is is it under PC Act?
It's under PC Act. There is a charge of PC Act also. And my lord, that whole proceeding is now under challenge before this honorable court because the investigation was not done in the manner required under the PC Act. So it's under stay. It your stay, isn't it? So it's under stay still, my lord. The proceedings under stay still, my lord. And there was no sanction also, my lord, because the court was asking for sanctions. Sanctions were also not there under the PC Act.
No, but charge has been framed.
Charge, my lord, charge has not been framed. Charge not framed. My lord will come to page 48. That's the first order. In the first charge sheet that was filed, my lord, cognizance were taken against the accused persons. Summons were issued. But subsequently, my lord, at page 49,
The promotion to which post?
Executive engineer. I'm an assistant executive engineer. The
So
meeting
your-
was held on
Your
19th.
name has already been shown in the gradation list. of
As,
executive.
as follows.
What is the meaning of this, Mr. Nayak?
Will kindly see the first charge sheet, Lordship.
Hmm.
At page 41, Lordship. Lordship, may kindly see the date 31/7/2017. Page 41, Lordship. 31/7/2017. And at page 24, Lordship will get the date of DPC, Lordship.
Page?
24.
In 6. It will be 19/6. The promotion on the 19/6.
The DPC was conducted on 28 June 2021.
No, it is on 19/6/2021, orders on 28/6.
Whatever.
Whatever, it is after the charge sheet.
Lordship.
After a charge sheet. Now, Lordship, at
Once a
page-
charge sheet is submitted, either the court will have to frame charge or will have to discharge.
Discharge.
The only other option available is for further investigation. Therefore, even if the learned court has said reinvestigate, there is no power of reinvestigation.
My lord,
So it is
I'll
always-
satisfy your logic. My lord will come to page 49. There is no power. I'm sure, I'm concerned. But in this peculiar facts, my lord, in this case, that happened, my lord.
Hmm.
Accused are absent without steps so and so, heard both sides and the petition is allowed. I have gone through the record and seen that there is some mistake in the charge sheet. And as such, it appears to be that the further investigation on certain point is necessary. Hence, let the case record be sent to so and so to reinvestigate the matter and submit FF at the earliest, inform accordingly. Now, my lord, the next charge sheet came at page 50, my lord.
So the order itself mentions that some further investigation.
But how the police has taken it, my lord, it's for reinvestigation. It was this. 156.
No, Mr. Nair, you see, we cannot interpret law on the basis of understanding of.
My lord, my case is that charge sheet was there. That was never acted upon, my lord. That charge sheet has got no existence as on today. That's my case, my lord. If that charge sheet has, for whatever reasons, criminal law will take its own course, my lord. But so far as the issue that I'm trying to place before my lord, that charge sheet has got no
So
existence.
then you have to get the declaration from in the criminal petition that charge sheet is gone.
Because, my lord, here also,
How can the read
this affidavit, if I may just,
Mr. Nair, please,
I got my point. I got my lord.
we will not say that charge sheet is gone.
My lord will see, because that second paragraph of page 2, my lord, it's an affidavit filed in another case by the my lord, the Subanda police.
No, Mr. Nair, please.
I got it, my lord.
Please understand the point.
I got it, my lord. Further
You
investigation.
may be justified, you may not be justified on that, but can this bench, civil bench 3 say that the charge sheet is gone?
My lord, what I wanted my lord to do, because of the facts that are involved here, that charge sheet not having been acted upon, and it have been kept in cold
Then
storage.
you get an observation that the charge sheet cannot be acted upon. It is non-est in eye of law. Then only Janki Raman will kick in.
That's true.
Otherwise, how can Janki Raman kick in?
But in the second, my lord, there cannot be two charge sheets in the same offense, my lord.
Please get a clarification.
My lord, I got lordship. I'll do that. I'll try
That the only charge sheet will be these.
This.
That
that.
will take cognizance of that order and
Fine, my lord.
go proceed on the basis that there is only one charge sheet.
Lordship. That would be, my lord.
Then we are going to go on the track of service jurisprudence.
Lordship,
not on the
I was
criminal.
only trying to, my lord, bring my lord in that track only. But
You
I
are
understand.
right, but can this
No,
court
madam.
pass an observation of that?
If my lord,
When the
that
criminal petition is pending and the learned judge is in session of the matter,
is
right?
true.
Then it will amount to deciding that.
That petition, the earlier one, my lord. My lord will have it after 4 weeks, 2 weeks, 3 weeks, my lord. In the meantime, let me-
Four will be better.
Four will be better.
Lordship, that
But
issue,
what is this all happening? You have included his name in the gradation list of executive engineers.
Lordship, some,
It is just for a technical reason because in order to write out a judgment, we have to proceed in a line.
Right.
Otherwise, there is nothing.
Nothing.
Why you have done it? You have done it. You have already made him a part of the executive engineers cadre.
Lordship, that is.
The
But
committee
in
of
the, in
errors.
this case, Lordship, only issue is whether the search sheet of 2017 is a valid one or not.
If
Lordship.
they succeed in getting an order that the earlier charge sheet has become non-est.
Lordship, then the petitioner
We'll
will
allow this
definitely have-
petition in 5 minutes,
Lordship. that
maybe
is-
even
that-
4 minutes.
That is the only issue.
Oh, I got it.
And
Out
so
of
far
the
as,
4 minutes, 3.5 minutes will be given to you.
and so far as that issue is concerned, also one criminal petition is
Petition
already
already
pending.
That's what I'm pointing
No,
out.
We will do that.
If
We'll
Mr.
do.
Nair can get a clarificatory order from there. It's a matter of 5 minutes. What is
No,
there
we'll
in
do
this?
We'll do that. We'll try.
But Mr. Nair,
I got it, man. I got it.
there could be some error on the part of the learned
I
judge,
understand, man. Understand.
but the idea appears to be further investigation.
Further investigation,
But
end
if the
result was-
charge sheets have been delinked,
really.
what consequence it will have under the law? That is a matter that calls for.
My lord
examination.
cannot. It will be the
But it
criminal.
can't be done by a
No,
civil
no.
registry service matter bench.
It'll be, my lord, by the criminal court. I'll do that one.
Mr. UK Nair, learned senior counsel for the petitioner as well as the petitioner appearing in this case submits that the original charge sheet submitted in the year 2017 has become non-est in eye of law pursuant to the subsequent charge sheet submitted by the IO
In
in
20,
terms of the order dated,
my lord, give me page 49. my lord.
order dated 08/08/2019.
Lordship.
And therefore, the ratio laid down in the case of Janaki Raman cited in side of Chaudhary Tata Singh would, as well as Anil Sarkar, would come into play in this case. In view of the above, the petitioner's case cannot be kept in a seal cover since there was no charge sheet filed on the date on which the DPC had met. Full stop. However, the declaration on the validity of the charge sheet cannot be made by this court in exercise of jurisdiction, in exercise of the present jurisdiction. Full stop. Situated thus, Mr. Nair seeks adjournment of this case for 4 weeks so as to enable him to obtain appropriate clarificatory order in the criminal petition pending before this court. Mr. P. Nayak, Standing Counsel, PWD Assam is present.
Much obliged.
Lordship, I appear for respond number 4.
All right, and Mr. D. Bora, Government Advocate Assam is present for 4, 1, 2, and 3. Mr. Nayak.
Oblige that.
Nayak Sahab, 1, 2, 3, and 1, 2, 3. All right. 1, 2, 3.
1, 2, 3, Lordship.
Yes.
1, 2, 3, 4 also, Lordship. BTC is there.
4 also. But he wants 4.
Home Department.
4, 3.
Mr. Bora, you are willing to concede 4? No.
Your Lordship.
Sorry,
Five. Please, BTC. 5, I'm 5, I'm sorry, 5.
1, 2, 3, 4. Yes.
That in this case, Lord, the petitioners were engaged as a casual employee in the Brahmaputra board. All of them were disengaged. Thereafter, they raised an industrial dispute and an award was passed in their favor. Award of reinstatement. And so for the back wages is concerned, Lord, it was computed by rupees 2,000 rupees. Now they have challenged that award. And these during tendency of this award, my lord, we have been called upon to join our duties pursuant to an order passed by the Honorable Court. Now, my lord, we have been asked to work the monthly rupees of 5,000 on this.
Let's
That is
see.
far
70.
below the rate of minimum wages.
Mr. Talukdar, sorry, Mr. Dev Chaudhary. See, the point is this 17B is in lieu of reinstatement, correct?
When you are not willing to reinstate, then 17B will come in. But
Lordship.
you can't say, I'll give you 17B, but you have to earn your bread. Both you can't say. I'll give you minimum wage as per 17B, but that you have to get it by working. That is absolutely preposterous.
Lordship, yes, in fact, they could not have been worked if 17B was there.
So who has done this? I don't know.
There is some, because their view is, of course, not going into 17B, we are simply paying. So
Then pay
those,
them the current wage.
Lordship,
Why don't you obtain instruction and we'll finish it off? This is why torment these people unnecessarily. If they're working, then you have to give them the wage that they're
in
entitled
fact,
to.
I had a discussion with the officers. And their view is, since we are paying something, so
No. Forget it.
now.
They want
no,
the order to be passed by the court. That is our, my instruction is also.
Let
They are in my favor.
me,
Officers, sir.
if your Lordship.
Or if you want, then I can pass the order.
That is
No,
the
Lordship,
problem.
that will be a detriment to me. Therefore,
It is
therefore,
also my
Lordship-
instruction.
We don't want there should be any detriment to
no,
you.
Lordship, therefore, Lordship, let me take it up, if it can be in the next week, I'll. Because if they are work, Lordship, then they have to be paid the wages. And if otherwise, it will be the 17B.
And the balance arrear with interest at the rate of 9% per
Bal-
annum to be
Balance,
recovered
Lordship,
from the
I am
salary
told,
of
Lordship,
people.
they have been paid, whatever arrears are there,
Huh.
that has been paid,
No,
Lordship.
from the date on which they were reinstated, they have to be given the wages which were normal wages which are applicable. Because they are earning the wages by working.
Yes, Lordship.
And the scheme of 17B is completely
In lieu.
different.
In lieu,
That is in lieu.
I understand.
So how have these people interpreted this law? They have become big interpreters of law.
Lordship, that is a big problem, Lordship. Departments have got their own law officers who sit in the office. So that is the issue, Lordship.
But you see, these are not good. These are bad
This is in
trends.
fact, Lordship, not
These are
correct.
bad trends and people are trying to act too smart.
This,
And against whom? These poor people, these
this
wage
is
earners.
Lordship. That I was.
You show your smartness against them. The whole world is there. Show how smart you are elsewhere. Why against these people? They are barely 5,000 rupees. Is it an amount on which a
Lordship,
person can survive?
I do understand, Lordship.
So I'm dictating the order in the chamber. I'll sign it the day you want. This can't happen. This is totally wrong.
Let it be on first, Lordship.
1st June.
It's a,
1st June, he will get the order. 1st June, he will get the order.
yes.
Let him have his satisfaction.
Yes, sir.
But there will be interest unless the department does it on its own, because they have been subjected to court proceeding. So interest means where? The date on which these people have started working. With effect from that date, they will have to be given the normal wage. Because they are earning it by their work. It is
Yes.
not a wage given to them under 17B in lieu of reinstatement. Correct. So whatever is the differential amount,
That has
that
to
will have to be paid to them along with interest at the rate of 9% per annum to be recovered from those law experts. We'll mention it. Legal experts,
this,
they will have to bear it.
not only this, Lordship, in other places
They will
also,
bear
I
it.
have seen that,
This
Lordship.
this is not permissible.
this-
This is not a bona fide stand.
Because
tell
it
them
is
that.
similar, 25 workers are involved. Some
Tell
of
them
them
that
were
the court
asked to
says
work
this
at
is not
Rohit.
bona fide.
Some of them were asked to Dhamaji. They could
If
not
this
go
is
there.
the way you show your muscle and power to these people, they are barely surviving. In a country like India, these people are barely surviving. They have their families. They have people to take care. 5,000 rupees.
That he has to go Dhamaji.
That is where people are showing how smart they are. Distorting interpretations of law, and there are hundreds of judgments on this point.
Yes.
So, Mr. Dev Chaudhary, this
Lordship,
court will not take
I'll
this.
take
risk.
it up, Lordship. Lordship will file.
If you
Also,
can't
and-
come to the rescue of these people, then what is the point in having a?
Yes.
Mr. A. Das on the request of Mr. Devpur, this matter be listed again on 1st of June, top of the list. This is top of the list season.
Well, Lordship,
First
that,
item.
no, that day I made the prayer because Lordship, some other matter was, I do not have any difficulty.
No,
Lordship.
that's all right.
Not having-
First item.
Lordship,
As first item.
Lordship.
Yes.
For hearing item 5.
The last occasion, my claim was directed to
Last occasion was when? When was it?
9, no,
When was the last occasion?
that is not written in my file, I'm sorry.
I'll tell you, 31st of March.
Yes.
What time did you come to court on that day? You don't remember. Then how do you expect the court to remember what happened in the last occasion? You have to start from the beginning.
Yes, madam. Matter relates to promotion, my lord. The petitioners are before, petitions before your lordship are working as grade 4 employees. My lord, they are claiming promotion, my lord, to the post of grade 3. Earlier also, they approached this honorable court, my lord. This honorable court directed the authorities, my lord, to consider their cases for promotion.
Grade 3 they are matriculates.
They are high secondary person. High secondary person.
But grade 3 graduation is required, is it
My
not?
lord, that has been amended in 2015.
Hmm.
The amended rule came in 2015. It was, my lord, the writ petition was filed, earlier writ petition, my lord, it was filed in 2010. And my lord, the order was passed, my lord, by this honorable court, my lord, on 3/11/2015.
Where is the rule? Where is the rule? Can you show the rule?
Yes, my lord.
You have that book, no? That is there in the chamber, I think. 1967 rules.
Rule,
There is a rule, a relaxation clause.
Yes.
Relaxation. You file applications for relaxation of qualification norms.
yes, my lord.
We'll ask them to consider.
My lord.
If you succeed in that, then only question of consideration for promotion. Rules will be applicable on the date on which the consideration is made.
Recently,
the
my
law.
lord, that has been, that has been, my lord, interpreted recently, my lord, by expert, my lord.
Which judgment? Can you show me the judgment?
In the case of Santosh, my lord.
Latest one is Lordship state of, it is Rashna Hills judgment, Lordship, one Rashna Hills. It was an appeal filed by the state, Lordship, state of Himachal Pradesh, I think. My judgment is in
Yes,
one.
Rajkumar, my lord.
No, that was the earlier one, subsequent one is Rashna Hills. Lordship, here, Lordship may kindly see order is it 14 to 2023, Lordship.
Is it any, is there any provision to relax power to dispense with the relax because 15 is there?
Generally, in every serviceable one,
Let them make an application.
no, Lordship, so far as one petitioner is concerned, Lordship, that is why I'm showing your Lordship order is it 14 to 2023, Lordship. Lordship, here, out of the 6 petitioners, Lordship, 5 were regularized against personal post. So their case, he has already considered, Lordship, that in terms of the division benches order, they cannot be considered for promotion to regular category. So far as respondent number 6, petitioner number 6 is concerned, Lordship, he was regularized against a vacant post, Lordship. So only his case is to be considered as he was not personal against personal post, Lordship. That division bench judgment does not apply against him. So his case was also considered. Lordship will find the speaking order at page 75, Lordship. And it was rejected because of the educational qualification that your Lordship is referring, Lordship. So against this, challenging this order, the present writ petition has been filed. If Lordship directs, if he files a representation, Lordship department will definitely consider
In respect of the personal post promotion, my lord, the person is holding personal post. My lord, I have found a decision of the ex court, my lord.
That
The
decision should not
ex
be
court
reopened.
says
Lord.
that, my lord, they are, my lord, temporary addition to the cadre. They are temporary addition to the cadre.
No, but the problem is you have joined them together. That's the problem.
Yes. That is true, my lord.
That is another completely different area. This- For petitioner number 6, it is a different area.
Yes.
For others, it is a different area. First, you have to show that you are at all entitled to be considered, even if you are graduates. Then also you are not entitled to. Then there is no point.
But in respect of petition number 6, he is entitled, my lord, because his regulation was way back in 1995, and I guess a permanent post, not personal post. And the other petitioners, my
But
lord,
that is not the case here.
and my lord, the rejection they have made by the impugn order on the ground that they are not qualified. On the ground that they are not qualified, they did not have the graduate degree. That is the only, my lord, ground of rejection, not the ground that they are holding personal post and all, my lord. That is why the common petition was filed.
Just a minute.
Ma'am.
This amendment was carried out in which year? 2015.
15, madam. In the month of October, madam. October 2015. October, I'm sorry.
So let him make an application under Rule 15 for relaxation of educational qualification.
Department will consider.
Department to consider. And 1 to 5, nothing can be done. If you have a-
1 to 5, I will place his husband before lordship. The lordship can consider, my lord.
No, two different sets of relief we cannot give grant in one petition. Then you have to withdraw and then you have to file a fresh.
Consider this, my lord, then my lord, perhaps my lord, same relief can be granted to the other persons also.
What is this?
My lord, paragraph 11 to 14, my lord.
Hmm. What is the point, Mr. Saikia? What is the point here?
Here also, my lord, this on the expert says that, my lord,
Louder. Hmm.
in this case, my lord, now Lepus could hail that, my lord, the persons appointed against personal post, they are temporary addition to the cadre and they cannot be excluded from the purview of promotion.
Where is it? Which page? Which para? Have you seen this judgment, Mr. Nayak? Have you seen
The
this
basic
judgment?
distinction is that lordship here the post has been named as personal because it was created against my name. That is why it was called personal post. Now lordship, there is a specific feeder cadre lordship. If he is claiming promotion to a grade 3 post lordship, then there is a definite feeder cadre in grade 4.
This is not a part of the cadre.
No lordship. They are not even at par lordship. That is the-
Regulation order itself says that my lord, they are grade 4 employees.
No, this court judgment is there, that Dilip Kumar.
Yes.
Then
That
yeah,
is-
it is covered, their cases are covered.
My lord, that observation may be lordship record, my lord.
They were regularized against personal posts,
My lord.
grade 4 posts.
Yes,
Therefore, they don't form a part of the feeder cadre
lordship.
in the grade 4 for being considered for promotion to grade 3. In view of Dilip Talakdar, State of Assam, 2017 CSCC.
Their cases cannot be considered.
All right, take down, heard Mr. Ayat Saikal, learned counsel appearing for the writ petitioner. Also heard Mr. P. Nayak, learned standing counsel, PWD Assam appearing for the respondent numbers.
1, 2, 3, 4.
1, 2, 3, 4. And Ms. A. Talukdar and the government advocate Assam for respondent numbers 5 and 3. Full stop. These 6 writ petitioners hearing are working in grade 4 posts under the in the establishment of
Executive engineer, Silchar Rural Roads Division, my lord.
Executive Engineer, Silchar Rural Roads Division, Silchar. That is the respondent number 4. Aggrieved by non-consideration of their case for promotion, the petitioners have approached this court for the second time by filing the instant writ petition, inter alia assailing the speaking order dated 6/12/2017, passed by the respondent number
One, my lord.
respondent number 1 in terms of the orders passed by this court in WPC number 5606/2010, 5 WPC number 6103/2010 and WPC number 6232/2010. Full stop. 2010, rejecting their prayer for promotion to the higher cadre of grade 3. Full stop. Then you take down. It appears that the writ petitioners are not graduates, but are only HSLC pass candidates. Full stop. The question of promotion of the petitioners can only be considered in accordance with the provisions of Assam Ministerial District Establishment Service Rules 1967. First up, the amended provision of Rule 6, bracket 6, bracket B. Requires that the incumbent should be should have passed degree examination in any discipline from a recognized university. Full stop. However, none of the petitioners are bachelor's degree holder. Be that as it may, there is a larger problem in case of petitioner numbers 1 to 5, in as much as these petitioners were apparently regularized in the grade 4 posts held by them, which were personnel posts and therefore did not form part of the feeder cadre in grade 4 for promotion to the next higher post of grade 3. Full stop. After the judgment of this court in the case of Dilip Talukdar and others versus State of Assam and others reported in 2017 bracket close 3 GLR 376. Their cases cannot be considered for promotion to the next higher grade. Full stop. However, there is no doubt or dispute about the fact that the petitioner number 5, namely petitioner number 6, namely Mishri Lal Kahar, was regularized against a regular vacant post. A regular vacant grade 4 post pursuant to a proper selection process, and therefore his
Selection process, Lord. Page 33.
regular vacant post
Brought under regular establishment against vacant post.
the petitioner number 6 was brought under the regular establishment against
A
a
vacant.
vacant post in the grade 4, and therefore his claim would not be hit by the law laid down in the case of Dilip Kumar Talukdar and others supra. Full stop. The only problem with petitioner number 6 is that he does not possess a bachelor's degree. Full stop. Next, the rules of 1967 contains a provision in the form of section 15, which permits the authorities to dispense with any provision or relax any rule if the same causes undue hardship in a particular case. Full stop. However, power under Rule 15 of the rules of 1967 can be invoked only when such an application is made before the competent authority by the aggrieved party. In view of the above, this writ petition stands dismissed insofar as petitioner numbers 1 to 5 is concerned. Petitioner number 6, namely so-and-so, is however granted liberty to file appropriate application under Rule 15 of the rules of 1967. First up, if such an application is filed within 4 weeks from today before the competent authority by enclosing a copy of this order, the same be considered objectively and be disposed of by a reasoned order. Subject to outcome of the said process, the case of the petitioner may be considered for promotion to a grade 3 post in accordance with law, along with other departmental candidates. The petition stands disposed of. What else? What is the IA?
IA is not.
Take this back, you will need it. Yes, so that's enough. Anything else?
Seven, my lord, issue is pending before the Honorable Apex Court, my lord, regarding regularization of work stars and master workers. So, Lordship may take up the matter after, my lord, disposal of the SLP, my lord. I have got the.
Mr. Ayat Saikal, learned counsel for the petitioner, as well as Mr. B. Goswami, learned additional AG Assam, appearing for the respondent, have both submitted that the core issue involved in the petition is pending adjudication before the Honorable Supreme Court of India in SLP.
SLP number 38056 oblique 2027. 2017. Sorry.
2017. And therefore, hearing of this matter be adjourned for 8 weeks, awaiting the verdict of the Supreme Court. Prayer allowed, let the matter be listed accordingly.
Obviously.
What is happening here, Mr.
Well, the report received from the medical board, we have given a copy to them. And on last occasion, Lordship has directed them to examine the report and come.
My lord, Lordship also had asked us to obtain instruction, my lord. If your Lordship kindly produces the report, my lord, He is at present having benefit of myoelectric prosthesis fitted on his right upper limb. My lord, that company which provides in the whole of notice was named Otobook. It is a German company based in VIP Road, my lord. We have obtained instruction, my lord. They have shifted from notice Guwahati office, and another company where say another name is established at Hengrabari, my lord. We could learn, and we have also contacted them, my lord. If the lordship gives us some time, my lord, they could come to this honorable court, my lord.
So some electric prosthetic gadget is there.
There, my lord. It is also reflected in the my lord, medical
yes.
report, my lord.
Where is the report? Is it
But
there?
on last occasion, we have placed it. I have a copy, my lord.
Do you, Miss Chaudhary, do you have a copy?
But दिया नहीं copy to दिया नहीं oh they can't solve what did you
So is there any light in the end of the tunnel or not? Or we are just getting into legalities? Mr. Nath,
not you.
is there any hope for the boy? That's the only thing I am interested in.
The report suggests something, my lord. What did you But the report says that he is post-electric burn so and so. He is at present having benefit of myoelectric prosthesis fitted on his right upper limb and cosmetic prosthesis fitted on his left upper limb, and as such, he is able to perform some of the activities. Then the opinion of the board is that myoelectric prosthesis will benefit him to some extent in his day-to-day activities. So this myoelectric prosthesis, possibly he has contacted somebody and he wants to have some instruction. And from our side, my lord,
Yes.
My lord, in fact, my lord, on the earlier date, the learned additional AG appeared. He was to apprise before this honorable court today, my lord, with a proper rehabilitation scheme, my lord.
দাদা আছে না?
And in fact, your lordship produces the medical report, my lord. It says 90% permanent disability, my lord.
So what is the way forward? That's what I'm asking. What is the way forward?
Wait, this. No, but he can avail the, considering his physical condition, he can avail the benefit of myoelectric prosthesis fitted on his right upper limb and the cosmetic prosthesis fitted in his left upper limb. That benefit he can avail as per the physical standard of the person. And my lord, as per the some government scheme is there, and under that particular scheme, government can give him the financial benefit to an extent. But although that particular scheme is not for a government employee, because his father is a government employee, my lord, therefore, under that particular circumstance, the learned additional AG he submitted that he will come up with an proposal, my lord.
Yeah, but where is the proposal? March, we had made that request.
I appear on behalf of Mr. P.N. Goswami. My lord, he's in Kolkata, my lord, attending to a family emergency, my lord. He could not be here. His son has gone a surgery yesterday, my lord, so not here. Be taken up sometime.
Would you have anything to say, Ms.
I
Chaudhary?
will just have a word with Mr. Goswami perhaps and see how we can perhaps take it forward. Because the salsa is concerned, we don't really have the jurisdiction or to enter the matter.
No,
But it
more
comes
than
to the matter-
salsa, the court wanted your
Yes, Your Lordship, that's
valuable
what-
assistance.
Like, but I have already addressed Your Lordship back on the fact of constitutional tort and how perhaps this honorable court will proceed in terms of compensation, even if negligence is not proved on the APDCL, even then by way of the constitutional tort, I will address Your Lordships on the decision on that. Your Lordship would permit me perhaps-
Will it be possible for you to prepare a short note on what are your suggestions?
Yes.
On the next date, and we'll pass an order on the ground of Mr. Goswami, we will.
Yes.
Mr.
Ivy Guha, my lord.
Direct Counsel is present on behalf of the petitioner. Mr. D. Nath, Leonard, Senior Government Advocate Assam has appeared for respond numbers.
Here, Lordship, for one.
Respond number 1. And Mr. D. Chaudhary for respond number
So I appear for respondent number 6 and 7.
6 and 7.
Each of.
Ms. R.S. Chaudhary.
Can you?
Please give your whoever is appearing for, give it. Ms. R.S. Chaudhary, Mrs. R.S. Chaudhary, and
On number 10.
Standing Counsel Assam is present on behalf of respond number 10. Although the report from the medical board is available on record and called for by this court is available on record. Yet a prayer for adjournment has been made in this case today on the ground of personal difficulty of Mr. Ian Goswami, Leonard Additional AG Assam, appear in this case. First up, since a concrete decision would have to be now taken in this matter as to the benefits that can be provided by the petitioner. Without further delay, I am inclined to post this matter again after 4 weeks so as to enable the learned counsel for all the sides to come up with concrete suggestions.
My lord, we have already provided a compilation of judgment, my lord, from our side, my lord.
Judgment, I don't want. Who wants judgment? You tell me what are the solutions. We'll write a beautiful judgment. Is that what your client wants?
No, I'm sorry.
That- Yes, it will be after summer vacation now. 4 weeks after summer. Days after summer vacation.
My lord, this is with regard to a challenge made by the petitioners to a selection process for grade 4 posts in PWD. Now, my lord, the 6 posts were advertised. 6 posts advertised, the breakup of reservation was not given there. Then, my lord, finally, we all qualified. We are at serial number 3 and 4, my lord. Now, what the department has done, my lord, they have filled up 5 posts by way of reservation and 1 post by way of general, unreserved, my lord. 5:1. And my lord, they, by terms of orders of this honorable court, affidavits have been filed, and it has been clearly stated that from the preceding years, no posts were carried forward as backlog vacancies. Only the point was carried forward. My lord, if the point is carried forward, then my lord, 16(4)B will apply. And if 16(4)B applies, my lord, 50% ceiling would apply. 50%, my lord, herein would be, there are 2 categories of posts: peon, 5 posts, and my lord, the Chowkidar 1 post. Chowkidar general, I'm not with that. So, my lord, in the peon post, if 50% is applied, it will be 3:2, my lord. If it is 3:2, I come in because the person at serial number 2 has not agitated. My lord. This is the story here, my lord.
Who is for the department?
My lord, my friend appears.
I'm agreeing.
Ready with the matter?
Lordship may take up whole matter, Lordship. Lordship, just simple, my simple reply will be, Lordship may kindly see my affidavit, Lordship. Lordship, after selection, Lordship, and in the advertisement, there was no specification as regard reservation, Lordship, which post is reserved for whom. And when the matter was forwarded to the personnel department, they said in the cadre, Lordship, already more than 50% of general persons, 50% of the candidates are belonging to general caste category, Lordship. That is where personnel department said, fill up this post from the reserved category. WPT, I'm sorry. They said, fill up this post from the reserved category post. And that is that instruction we simply followed.
WPTBC is not a party here.
No. WPT is not a party because they had brought that thing in the affidavit. The affidavit.
Will it not have to be imputed as a party?
My lord, if my lord goes through the facts, the law, if my lord applies, WPTC's opinion, my lord, need not be gone into because here, my lord, the advertisement, my lord, would find at page 13, my lord. I'll just satisfy your lordship on that.
The total is 6 posts, 5 peon, 1 chowkidar.
1 chowkidar. Page 21 is the select list, my lord. And my lord, here we are at serial number 3 and 4. Person at 1 is unreserved. I've not made him a party. He has been appointed as Chokidar, my lord. Now, my lord would see serial number 12 and 13, OBC candidates. Respond number 6 and 7. Then, my lord, serial number 20, another OBC candidate, 3. Then, my lord, turns over serial number 55, STH. So, my lord, 1, 2, 3, and my lord, serial number 5, STP. Page 20.
That is the precise reason why we would have asked the WTT.
My lord, may, my lord, but may. That
But
will-
your client has not been appointed.
No, I have not been appointed. We have been pursuing this matter, my lord. And they have also said, my lord, whatever be that as it may, if lordship comes to page 50. There was a
Mr. UK Nayak, Learned Senior Counsel appearing for the petitioner, also heard Mr. P. Nayak, Learned, Standing Counsel, PWD Assam appearing for the
Rahul
respondents.
WPT. Rahul
After hearing the submissions made by Learned Counsel for the parties, this court is of the opinion that the Secretary to the Government of Assam,
WPT and BC.
WPT and BC is required to be included in this case, and the views of the said department be obtained before passing a final order. As such, Secretary to the Government of Assam, WPT and BC Department, Guwahati, is hereby included
11, my
as
lord.
respond number 11, registered to carry out necessary corrections in the cost rate and list the matter again by reflecting the name of learned SC WPT Assam in the
Art.
cause list on 12th of June 2023. In the meantime, a copy of the read petition. be furnished
Mr.
to the
Arthur,
learned-
my lord.
To Mr. Arthur, Learned Standing Counsel, WPT. and
Lordship, I'll do that. Much obliged.
Obliged.
May it please your lordship, my lord. My lord, here, my lord, matter particularly relates to my lord unauthorized absence from service of 347 days, my lord. Now, my lord, initially the judgment was delivered and the petition was dismissed. My lord, we made a challenge to that judgment, my lord, and honorable division bench, my lord, has remanded the matter back for, my lord, fresh consideration, my lord. My lord, hoping that in a
So
unauthorized.
first of all, how much time will you take?
It will take some time, my lord. My lord may fix a date, my lord, yes. Because the lawsuit is rising by 115. Next week, my lord, that may fix. We will not make a lengthy argument on the basis because honorable division manager deal with the entire matter itself. Now, what the punishment, if at all, required to be less punishment, that has to be decided. Because on the ground of unauthorized absence, my lord, the charge must be whether the charge should contain whether his unauthorized absence is willful, as per the judgment of the Kusan V. Parmar. And my lord, as per the CRP Act, my lord, that unauthorized absence is a less heinous crime offense. So in that view, for unauthorized absence, my lord, removal from service is not tenable.
All right, can you indicate a date after 12th June? Or Mr. BK, there's been a counsel for the petition also, or Mr. DSGI, Mr. RK Devkatri, Learned DSGI.
13.
Appealing for the respondents on the joint request of Learned Counsel for both the sides. Let this matter be listed for hearing again on 13th of June.
13th, 1-3, my lord.
1,
Obliged, leave
2020. It's a fixed item.
May it please your lordship. Lordship, the petitioner herein was a cook of the 46th Battalion of the.
How much time?
Lordship, it will. Additional lordship, it will take some time.
15th of June, same order, put his name. Or you can take a chance, if the division bench winds up and a single bench sits again, you want to take a chance, you can take a chance.
Let it be on 15th, lordship.
Item?
May please your lordships. I prefer adjourn the case for today, lordship. On behalf of P. Sharma is out of session.
Mr. K D Sharma, Lawyer Counsel appearing for the petitioner 6 adjournment in this case. Mr. V Kumar.
My lord.
Lawyer Counsel is present for the respondents and does not have any objection if the prayer is allowed. In view of the above, let this matter be listed for hearing again